Welcome to the deep dive. Today, we're tackling something maybe a bit unexpected, but with really high stakes, especially if you're into firearms training or thinking about it, particularly down here in Florida.
hmm
We're drawing from an article over on valortech.com from April 7th, 2025. It's called ITAR and Firearms Training in Florida, Safeguarding National Security in the Classroom.
Yeah, it's fascinating how this one specific thing, firearms training in Florida, opens up this whole can of worms about international rules affecting everyday stuff.
Exactly. So our mission today is to, really get our heads around these international traffic in arms regulations, ITAR, and how they, kind of surprisingly, impact who can legally get firearms training in the U.S.
It goes way beyond just learning to shoot safely.
Right. It connects directly to national security in ways that I think might be a real aha moment for folks, regardless of their background with guns or international law.
It definitely highlights that sharing knowledge, especially certain kinds of knowledge, isn't just about the skill itself. There are serious legal frameworks around it.
Okay, let's dive in. What exactly is ITAR, and why should someone maybe thinking about a tactical pistol course care about this?
Okay, so ITAR stands for International Traffic in Arms Regulations. It's basically a set of U.S. federal rules. Think Title 22, Code of Federal Regulations, Parts 120 to 130.
Right.
They're run by the State Department's Directorate of Defense Trade Controls, the DDTC, under a bigger law called the Arms Export Control Act.
And the main goal.
Protect U.S. national security. Simple as that. It's
Yeah.
about controlling the export, the sending out of defense-related things, and, importantly, services, keeping sensitive stuff out of the wrong hands.
Okay, export defense items. Sounds like shipping tanks overseas, maybe.
That's what most people think.
Yeah.
But here's the twist, and it's crucial for this discussion. ITAR isn't just about hardware. It covers defense services.
Defense services? Like what?
Well, the regulations define it as providing assistance, including training or technical info related to defense articles. And this is where firearms training comes right into the picture.
Ah, okay. So teaching someone how to use a specific firearm could be a defense service.
Precisely. You might think you're just teaching safe handling, maybe some defensive drills, but from ITAR's perspective, you could be exporting controlled knowledge.
And firearms themselves are definitely covered.
Oh, absolutely. Category I of the U.S. munitions list, the USML, explicitly includes most firearms and ammo. And like we said, training related to these items is a defense service.
So putting it together, teaching someone to use a gun listed on the USML, that's potentially an export act.
Essentially, yes. An export of knowledge or skills. And this isn't new either. The article points out that since way back in 1985, you've generally needed a license from the State Department to train someone who isn't a U.S. permanent resident in the use, maintenance, or operation of any item on that munitions list.
1985. Wow.
Yeah. So the key takeaway here is, if you're thinking about teaching shooting, tactics, gunsmithing, anything related to USML firearms to someone who's considered a foreign person, you almost certainly need the U.S. government's okay first.
Okay, that term foreign person seems critical then. Who exactly falls into that category under ITAR? It's not just people living outside the U.S., is it?
No, and this is where it gets really specific and catches people off guard. ITAR defines U.S. persons pretty clearly.
Yeah.
U.S. citizens and lawful permanent residents, green card holders.
Okay, citizens and green card holders. Got it.
Then there's foreign person. And the definition, according to 22 CFR section 120.63, is basically everyone else.
Everyone else. That's broad.
It is. And crucially, this includes people who are physically present in the United States but don't have citizenship or a green card.
Like who? Give me some examples.
Think international students here on F1 visas, tourists visiting from abroad, even, and this is a really fine point, someone who has applied for asylum but hasn't had it granted yet.
Wait, really? Someone seeking asylum here is still a foreign person for ITAR.
That's right. Now, if someone has been granted asylum or they're recognized as a refugee, they become protected individuals under immigration law, and ITAR treats them like U.S. persons. But while that application is pending, still a foreign person.
Wow. Okay, so for an instructor, that distinction is absolutely vital. You can't just assume someone living here is okay to train.
Exactly. So if you have someone walk into your class who isn't a U.S. citizen and they don't have a green card or that official refugee status, you generally cannot legally provide them firearms or tactical training without specific government permission via an export license.
And this holds true even if they can legally, say, rent a gun at a range, or maybe even own one under other law.
Yes, that's the part that really throws people. Other gun laws might allow them certain access, but ITAR is a completely separate layer of regulation focused purely on controlling the export of defense knowledge for national security reasons.
The article mentioned a Florida training company's policy.
Yeah, good practical example. They explicitly state courses are only for U.S. citizens, green card holders, or recognized refugees, citing ITAR. It's not just them. The NRA Trainer's Guide apparently also warns instructors about these restrictions.
So, seeing foreign tourists taking a tactical rifle class somewhere, that should probably make you pause and wonder if the instructor knows the rules.
Absolutely. It's a potential red flag. Are they checking status? Do they even know they need to check?
Okay, let's play out a scenario. An instructor, maybe well-meaning, runs a defensive pistol class. A student signs up, seems perfectly fine, maybe has a student visa. The instructor doesn't know about ITAR. What just happened?
Legally, that instructor may have just committed an ITAR violation. They've effectively exported a defense service, the firearms training, to a foreign person without a license from the State Department.
Even if it was just basic safety and handling, does intent matter? Like maybe the student is from an allied country.
Intent, in terms of why you train them, generally doesn't negate the violation itself. And ITAR doesn't really distinguish based on the student's home country being friendly or not for the basic requirement of needing a license. The rule applies across the board.
And that definition of defense service is broad enough to cover typical training.
Very broad. Again, it's furnishing of assistance, including training, to a foreign person in the use of defense articles. Since firearms are defense articles on the USML, training in their use fits squarely in that definition. It's export controlled.
What about the argument that it's civilian training, not military? Does ITAR make that distinction clearly?
That's a common hope, but the regulations themselves and guidance from agencies like the Department of Justice don't really carve out a clear exception based on whether you call the training military or civilian if it involves items on the munitions list.
So no loophole for basic training then?
Doesn't seem like it. The DOJ has been pretty explicit. A license is needed to train any non-permanent resident alien in the use, maintenance, repair, or construction of munitions list items. They don't mention an exemption for just basic stuff.
Okay, but where's the line? What if it's just supervised shooting at a range, like those tourist experiences in Vegas?
That's a good point. There is likely a difference. A purely fun shoot where someone rents a gun and shoots at a target under supervision but without actual instruction on technique, tactics, maintenance. That probably doesn't rise to the level of training or a defense service under ITAR.
So just pulling the trigger is okay, but teaching how to pull the trigger effectively isn't?
Kind of, yeah. The moment you start teaching stance, grip, sight alignment, trigger control, malfunction drills, tactical reloads, how to move and shoot anything beyond just the absolute basics of point and click, under supervision, you're likely crossing into providing a defense service. You're transferring knowledge and skills.
Like that quote from the training owner mentioned.
Right. Tactical and firearms training classes are covered under ITAR and are thus restricted to U.S. citizens' legal residence. Pretty clear stance.
This sounds incredibly restrictive. Is there any legitimate way for an instructor in the U.S. to actually train a foreign national?
Yes, there is. ITAR isn't an absolute ban. It's more like you can't do this unless you get permission. There's a formal process through the State Department.
Okay, and what does that involve? Is it easy?
No. Not really easy or cheap, especially for small operators. First, the instructor or their company generally needs to register with the DDTC as an entity involved in defense trade, specifically as an exporter of defense services.
Registration, okay. Is that a one-time thing?
Nope, it's an annual registration.
Yeah.
And there's a fee, which the article mentions was around $2,250 per year at the time. It might fluctuate.
Wow, okay, just to be allowed to potentially apply for licenses.
Exactly. Then for each specific training engagement with a foreign person or group, you typically need to apply for an export license. Often, this is what's called a Technical Assistance Agreement, or TAA.
And that's another application, another fee.
Usually, yes. There's often a processing fee per application, maybe around $250 or so. And this application is detailed. You have to spell out exactly who you're training, their nationality, background info, and precisely what skills and information you plan to teach.
And how long does all this take?
Significant lead time. Getting the initial DDTC registration might take, say, 45 days or more. Then each license application can easily take another 4 weeks, often longer. The government needs time to vet the student, the country, the proposed training.
So months of lead time, and thousands in potential costs before you can even start training one foreign student.
Pretty much. And even once you get a license, it's very specific. You have to stick strictly to the training content that was approved. No going off script with extra tactics or techniques.
This sounds completely impractical for your average local firearms instructor or small school.
For most, yes. Unless you have a specific, high-value contract or consistent demand from foreign clients who are willing to pay a significant premium to cover all these administrative costs and the time involved, it's just not usually worth the hassle.
Which explains why most just limit classes to U.S. persons.
It's by far the easier, cheaper, and legally safer route. Avoids the whole complex export licensing regime entirely.
We've danced around it, but let's hit it head on. What happens if an instructor does violate ITAR, maybe unintentionally? What are the real penalties?
This is where it gets incredibly serious. Violating ITAR isn't like getting a speeding ticket. It's a major federal offense. The government sees unauthorized export of defense articles or services as a direct threat to national security.
So we're talking big fines.
Huge. Civil penalties imposed by the State Department can go up to, well, the figure often cited was $500,000 to violation. But with inflation adjustments, that number can now exceed $1 million per violation.
Per violation. So training 3 unauthorized people could be 3 separate violations.
Potentially, yes. The fines can stack up incredibly quickly, and it's not just fines. Other civil penalties can include seizure of assets, firearms, equipment, property, and debarment, meaning you're banned from participating in any future defense trade activities.
Ouch. And that's just the civil side. What about criminal charges?
That's where it gets even more severe. If a violation is found to be willful, meaning you knew about the rules and broke them anyway or were willfully blind to them, it's a felony.
Felony charges, meaning?
Meaning potential prison time. Criminal penalties under the Arms Export Control Act can include fines up to $1 million and imprisonment for up to 20 years. Again, that's per violation.
20 years for teaching a shooting class.
It sounds extreme, but yes. If you willfully provide ITAR-controlled firearms training to an unauthorized foreign person, you could face charges comparable to someone caught illegally shipping missiles. And prosecutors can, and sometimes do, stack counts. Multiple students, multiple violations, potentially decades in prison.
That really puts it in perspective. This isn't a minor compliance issue.
Not at all. And the article highlights some real cases, right? A guy in Texas got years in prison just for sharing technical data with foreign students. FIR Systems paid a $30 million penalty related to unauthorized exports and training.
And the key point seems to be, I didn't know, isn't a valid defense.
Exactly. Ignorance of the law is generally no excuse, especially in heavily regulated areas like defense exports. Instructors are expected to know the rules that govern their activities. The potential for financial ruin, loss of livelihood, and significant prison time over what might seem like a simple oversight is very, very real.
You mentioned real cases. The article brought up the Daniel Duggan case, too, the former Marine pilot.
Yes, that's a very high-profile example.
Oh.
Arrested in Australia, facing extradition to the U.S. on charges of violating ITAR.
And the accusation there is training Chinese military pilots.
Allegedly, yes. Providing them with training on military aircraft carrier approaches and related naval aviation tactics through the third-party flight school in South Africa, all without getting U.S. State Department approval.
So even though it's aviation, not firearms, the underlying principle is the same, right? Exporting defense knowledge without authorization.
Precisely. It demonstrates the government's willingness and reach in enforcing these export controls, even when the activity happens overseas. The core violation is a U.S. person providing restricted defense services or technical data to foreign nationals without a license. Whether it's fighter jet tactics or advanced rifle marksmanship, if it falls under ITAR, the principle holds.
And the potential decades of prison time sought in that case really underscores the severity.
Absolutely. And it's not just pilots. There's that university professor prosecuted for sharing rocket propulsion tech. It shows the focus isn't just on hardware. It's very much on the unauthorized transfer of know-how.
Shifting gears slightly, the source material also talks about ITAR compliance, not just as a legal thing, but almost as a patriotic duty for instructors.
Yeah, it frames it that way, especially considering many instructors come from military or law enforcement backgrounds. The idea is that these regulations exist for a reason: national security.
To prevent potential adversaries from learning skills that could be used against the U.S. or its allies.
Exactly. Think of it as OPSC, operational security, but applied in the civilian training world. You wouldn't hand keys to the armory to just anyone. Similarly, the argument goes you shouldn't be teaching potentially legal skills involving controlled defense articles without ensuring the recipient is authorized.
Kind of like not training the enemy.
In a sense.
Yeah.
The article mentions concerns about individuals trained in the U.S. potentially using those skills harmfully elsewhere later on. So it encourages instructors to ask themselves, do I really know who I'm training? Could this knowledge be misused? If there's doubt, especially regarding eligibility, the safest and perhaps most responsible course is not to proceed without clarification or authorization.
And adhering to ITAR also reflects on the instructor's professionalism.
Definitely. It shows they understand the broader legal and ethical landscape they operate in. It signals a higher standard, a level of seriousness beyond just the mechanics of shooting. It builds credibility. That quote from the legal guide was pretty stark.
The one about high stakes and ignorance being unacceptable.
Right. The stakes are high. Violations can result in civil and criminal penalties, including up to 20 years imprisonment. Firearms companies should have a clear understanding of this area of law. It positions compliance as non-negotiable for serious professionals.
Okay, so for people listening, maybe someone looking for training or a law enforcement officer tasked with finding trainers, what practical steps can they take? How can they verify compliance?
Good question. The article suggests being direct. If you're a potential student, just ask the training provider. Do you comply with ITAR regulations regarding training non-U.S. persons?
And what kind of answer should you expect?
A knowledgeable, compliant instructor will understand immediately. They'll likely explain their policy, probably stating they only train U.S. citizens, green card holders, and maybe refugees at least. Or they'll mention having specific licenses if they do train foreign nationals. A confused, dismissive, or evasive answer, that's a potential red flag.
Are there other outward signs?
Look at their website or registration forms. Compliant instructors often have a clear statement about eligibility, mentioning ITAR or restricting classes to U.S. persons due to federal regulations. Seeing that upfront is generally a good sign.
And this is important for law enforcement agencies too.
Absolutely crucial. If an agency is sending officers to an external course or bringing in a private instructor, they need to ensure that instructor is ITAR compliant, especially if there's any chance foreign officers or visitors might participate alongside their personnel. There could be liability issues if unauthorized training occurs under their watch. They should double-check export authorizations if training involves foreign partners.
What about instructors who claim they can train foreigners?
Trust but verify. If they say they have the necessary licenses, they should be able to show proof their DDTC registration and the specific export license or TAA for that training or student. These aren't top-secret documents within that context. If they're hesitant or can't produce documentation, be wary.
And why should a regular student care so much about the instructor's compliance?
Well, beyond not wanting to be inadvertently involved in something illegal, it speaks to the instructor's overall diligence. If they're willing to cut corners on major federal regulations like ITAR, what other safety rules or legal requirements might they be overlooking? Choosing an instructor who demonstrates attention to ITAR compliance suggests a higher level of overall professionalism and responsibility.
The article we base this on, from valortech.com, naturally positions Valortech itself as an example of compliance.
Right. They use themselves as a case study. They highlight their status as a trusted ITAR-compliant training partner in Florida.
And they emphasize their policy.
Yes, being fully ITAR-aware and compliant, and strictly limiting training to U.S. citizens, green card holders, and other lawfully authorized individuals. They frame it as being about protecting national security, not just avoiding fines.
What benefits do they suggest come from choosing a provider like them?
Primarily, peace of mind for the student or agency. Knowing the training is 100% legal, conducted by instructors who understand and follow these complex rules. They imply that compliant providers stay current on laws, maintain registrations, and educate their staff, so there's less worry about legal trouble or classes being disrupted.
So, linking compliance with overall quality and integrity.
Exactly. They position ITAR compliance as part of being a patriotic firearms instructor and integral to their reputation, especially when dealing with law enforcement, veterans, and responsible citizens.
Okay, let's try to wrap this up. If you had to boil down the key takeaways from our deep dive today, what would they be?
First, ITAR International Traffic in Arms Regulations has a major impact on firearms training in the U.S., often in ways people don't realize.
Right, it's not just about shipping hardware.
Exactly. It controls the export of defense services, which includes training non-U.S. persons, anyone without citizenship or a green card basically, on firearms listed on the U.S. munitions list. Getting authorization usually requires a complex and costly licensing process.
And the consequences for getting it wrong are severe.
Extremely severe. Massive civil fines, potentially millions, plus felony criminal charges carrying up to 20 years in prison per violation. Ignorance isn't really a defense.
So compliance is critical for instructors, legally and ethically.
Yes, it's a legal necessity, and, as the article frames it, a matter of national security and professional responsibility.
And for students or agencies seeking training, verifying an instructor's ITAR compliance is an important step.
Definitely. Ask questions, look for policies, be cautious of red flags. It reflects on the instructor's overall diligence.
As a final thought, this whole discussion really makes you think, doesn't it? How seemingly local activities, like taking a shooting class, can suddenly connect with these big national security regulations.
It really does. It highlights how knowledge transfer itself in certain fields is something governments closely watch and regulate in our interconnected world. It begs the question, what other specialized skills or information might be subject to similar, less obvious controls?
Something to ponder. It definitely underscores the responsibility that comes with specialized skills. And as mentioned, if you are looking for ITAR-compliant training in Florida, Velotech was presented as one resource aware of these issues.
Good point. The bottom line seems to be, stay informed, understand the rules that apply to your activities, and always prioritize safety and legality.
Well said. A complex topic, but hopefully this deep dive shed some important light on it.